Everybody in. Yeah, everybody's coming in now. So just good morning, everybody. We're just going to let everybody in. It takes just a little while for people to follow through, Mark. Sometimes one of these things where, but hopefully everybody just automatically can just slot in.
Yeah, fingers crossed it works.
Yeah, Renters' Rights 3 months on. It's hard to believe how quickly it's gone. It's like we're waiting for it for years. I know as a landlord, well, my wife particular has been obsessed with its introduction, but now it's here. Kind of, we're slowly getting used to the new world. I think that's the best way to describe it, Mark.
Yeah, it's already the new normal, and it's nice that actually people seem to know about it as well, so it's not as much of a shock as potentially some changes have been in the past.
Yeah, I agree. Well, we certainly will be going into the detail this morning. So my recommendation is, if you've not really had much of an understanding of it, you'll certainly have a deep and meaningful understanding of it after this presentation. So
Absolutely. Well, now you've got your brew. Morning, everyone. Thank you for joining this. Myself and Roger are partnering up. The Renters' Rights Act has been in place now for 3 months. That's absolutely flown by. What me and Roger are going to touch on today is some details and some stats and some education around actually what have we seen. So what do we all need to know, but also what impact has it had on the industry? What impact has it had on lending? So Roger will cover that side. What impact has it had on the insurance side of things? That's what I'll cover. This presentation will hopefully last probably 40 to 45 minutes, but we can both talk a lot anyway. And then we'll jump into a Q&A at the end. So any questions that you've got, stick them in the Q&A here. We will ignore them through the presentation, but we'll jump into them all at the end, run through everything overall. What we will do as well is we'll get the attendee list at the end, and we will all reach out to you all with a copy of the link for the recording as well once this is set, so you're all fully aware and you can revisit this as and when you need to. I am Mark. I'm head of intermediary at C2 Insurance. I'm the little person on this call. Roger Morris is Mr. Buy-to-Let, so I'm going to hand over to Roger, let him introduce himself and run through all the lending side of the Renters' Rights Act and what we've seen. And I'll jump back in afterwards to touch on the insurance side. Over to you, Roger.
Thanks, Mark. Right, we're going to go on a journey of understanding the Renters' Rights Act. So I just want to make sure, Mark, that you can see my PowerPoint. Unfortunately, I do apologise for the picture of me, but as that's come up, which is perfect.
Yeah, your AI photos on there. Yeah, that's perfect.
Yeah. So good morning, ladies and gentlemen. I want to take you through the Renters' Rights Act that only affects England. It's one of those points which really have to emphasise that Scotland, Wales and Northern Ireland have had their own variations now for a number of years. So we're just going to talk about how Renters' Rights is an English act and really take you on a bit of a journey so you understand what this means for you and how this actually works. As with all our presentations, everything that we put into this, there's no tax or legal concerns over this. This is just taking you through the statute and the book itself. So hopefully everything that I'm going to be talking about today will be purely factually given and it doesn't really cause any challenges, unlike some of the presentation I'm doing when we're talking about some of the more complex aspects of things like incorporation. So the Renters' Rights Act represents the most significant overhaul of the private rental sector legislation in generations. Mortgage advisors must clearly understand how it affects landlords' rights and responsibilities and timelines for issuing tenancies and what documentation is needed and how to manage those properties, how to increase rent and the process to do this, and how to make sure that they abide by and follow the new rules right through to taking back possession of the properties. So this presentation will hopefully equip you with the accurate and practical details to explain to a landlord what the changes are, why they matter, and how they will operate in practice. This is a practical explanation of the Renters' Rights Act, which represents the most significant change to the private rental sector legislation since the creation of the AST, Assured Short Tenancy, under the Housing Act 1988. And for those older members, that was Mrs. Thatcher that introduced this particular act. The Housing Act 1988 introduced the AST framework, which had governed the landlord and tenant relationship in England for 3 decades. The new legislation replaces many of the core principles of that system and moves the sector towards a fully periodic tenancy, so APT will become the common abbreviation, with stronger tenant protections and more structured possession rules. So on the 1st of May, the new tenancy regime came into force, and the assured short hold tenancies will automatically then became an assured periodic tenancy. So it was an automatic transition. No tenancies or new tenancies had to be reissued. It was by operation of law, and that new section 4A of the Housing Act 1988, it's all automatic. You couldn't opt out. It was just going to happen. The only exception is not the Housing Act tenancy, for example, a common law tenancy. So if you had a common law tenancy or a lodger, then that was outside of this act. The AST and the APT is considered as one continuous tenancy, and you don't need to reissue safety certificates or reprotect the tenancy deposit. However, and we'll go into this, the terms and conditions of an AST are still the same terms and conditions that they can that they still have under an APT. In other words, an AST would have 1 month's notice and an APT is 2 months' notice. But because the AST transferred into the APT, they only have to give 1 month's notice unless or when a new tenancy is actually issued. And we'll get into that detail soon. So let me cover off the point of common law tenancies and how it affects tenants, and that they don't form the main basis of how properties in England are rented. So common law tenancies misconception: if the rent is over £100,000 a year, the old rule was about £8,000 a month, then this became a common law tenancy. And this comes out of the Housing Act 1988. Before 2010, high rent tenancies could not be an AST, so they defaulted to a common law tenancy. So they might have been given an AST, but because of the size of the rent, they became what was called a common law tenancy. So what changed? The £100,000 cap was removed in 2010, and high rent no longer determined tenancy type. A £10,000 a month tenancy can still be an AST today. So what is a common law tenancy? It's a tenancy that sits out of the APT rules and is governed mainly by contract. So when does it typically apply today? If the tenant is a limited company, if the property is not the tenant's main residence, certain resident landlord arrangements, and the letting that falls outside of a standard housing legislation. So does the Renters' Rights Reform change common law tenancies? The simple position: most common law tenancies will sit outside of the renters' right changes, and the reforms are primarily aimed at the AST or APTs. In other words, the mainstream private rental sector. Common law tenancy is already outside of that AST or APT framework under the Housing Act 1988, and it's governed mainly by contract law. If it's not an APT today, the core renters' right changes do not suddenly pull it into the regime, but do not assume no impact. This is where advisors and landlords can get carved out. Even if the tenancy itself sits out, some rules still cut across. Certain elements of reform agenda may still apply. So property standards, AWAB's law, landlords registration, and general consumer protection. So this presentation about the Renters' Rights Act is designed to help you understand what's the new legislation and what does it do. When the changes take effect, and these changes in the main have taken effect, how landlords regain possession under the new rules, what insurance policies can help mitigate the risk, and how advisors should guide landlord clients going forward. This legislation only applies to England. For comparison, our devolved nations' regulations to letting rules. In Wales, we've got the Renting Homes Wales Act 2016. In Scotland, we've got the Private Residential Tenancy, which was introduced in 2017. And Northern Ireland, we've got the Private Rental Sector Reforms under the housing legislation. These systems already remove traditional AST-style structures, which is why the changes in England are now being aligned with the rest of the UK. The Renters' Rights Act received royal assent on the 27th of October 2025 and introduces a series of reforms designed to give renters greater security, increase standards in private rented sector, and provides a more structured possession process for landlords. The real key components of the Act, and the one that certainly has always attracted as the most attention, is the abolition of Section 21 no-fault evictions. That's got to be the big one, and I'm sure the one you'll have the most interest in really understanding its impact in this presentation. Then there's the move to periodic tenancies, which now has come into effect, the extension of AWAB's law and the ban on rental bidding wars, limit to rent increases, the application of the Decent Home Standards, the new possession grounds for landlords, no blanket ban on tenants on benefits with children, the private rented sector database, and pets in rental properties. Each of these will now be covered in detail. So let's start with the big one, Section 21, no-fault eviction. Landlords can no longer evict tenants without a valid legal reason, and this applies to both new and existing tenancies, giving renters more security. Section 21 has historically allowed landlords to regain possession without giving a reason. I am a landlord. I could literally give notice to the tenant and could have previously just evicted them. This may be the most contentious part of the changes and one that receives the most attention. So from the 1st of May, landlords were no longer able to issue a Section 21 notice and regain possession of the property without a reason. And this sometimes referred to the ending of no-fault eviction. Under the new law, all tenancies are now a periodic assured tenancy and have no fixed end date. A tenant can end a tenancy by giving 2 months' notice at any time, subject to the tenancy agreement. However, if they were on an AST and transitioned to an APT, which the vast majority of tenants would have been, they only have to give 1 month's notice because the AST contract would have said 1 month, where APTs will require 2 months. So if you were to take a tenancy today, it would be an APT and you would have to give 2 months notice. Essentially, landlords like myself must rely on a Section 8 possession ground, which will require specific legal reasons. Landlords can still serve a valid Section 21 notice up until April 2026, and that date is now gone. But the reason I mention it is some of those are still going through the courts, and it's till the end of this month of which that whole transition will have passed. And I think it's important to understand that maybe a landlord says, well, I have issued the Section 21. There is a few of those that are still filtering through, but ultimately you can't issue a valid Section 21 notice. Brand new now, that's all gone. It's all Section 8. Under the current system, the Section 21 notice gives 2 months notice after an initial 6 months of tenancy. After the abolition, this route stops and the landlord must use the Section 8. So when now issuing a Section 8, it's got to be for the following: rent arrears, antisocial behaviour, or landlord's intention to sell, move in, or refurbish, depending on the ground. So this becomes a key word, ground, and it's the legal definition of grounds to do something. The minimum notice period can vary. For example, 4 months notice for some landlords to use grounds after the first 12 months, and I'll come to that. This is more related to houses of multiple occupation, which have their own specific grounds, and they fall outside the standard ruling of this particular act. Because the courts will need a valid Section 8 possession claim, the overall time frame for possession may be and will be longer and less certain than the old Section 21 route. If a valid Section 21 was served, it remains valid, but those are literally will be coming to the end now. Landlords must apply to the court within the required time limits, usually 3 months from a certain period, and it's important to understand that they've followed that. But I don't really want to cover this now, because that section or that ruling, really, if it wasn't in the courts now, it wouldn't really happen. So let's look at what a landlord would need to do, what I would need to do now. All possessions which now be through a Section 8 grounds. Landlords can still regain possession, but only where a defined ground applies. Common grounds will include. So your first ground is a ground A. So if I want to sell one of my buy-to-let properties, it must be up for sale for 12 months before it can relet. So if I do go down the eviction process through the Section 8, it needs to be up for sale for 12 months. What I can't do is evict the tenant, put it up for sale, have it up for sale for 3 months, for whatever reason, change my mind. It has to remain up for sale for that 12-month period. Ground 1 is moving either myself or my family into the property. And then ground for rent arrears is you need 3 months of non-payment of rent, and the possession process cannot take place till the 4th month. Previously, it was a 3-month period. So the tenant, in effect, under the new act, gets an extra month. There's the breach of tenancy or redevelopment or demolition, and that's really ultimately to do with the possession grounding of the local authority. Because possession must go through the court, timelines will usually be longer, and they are going to be significantly longer. So let's look at selling ground A, the reletting restriction. Under the Renters' Rights Reform, if I was to regain possession using the intention to sell under that specific ground, I cannot simply relet the property straight away if it doesn't sell. The rule: once possession is obtained to sell the property, the landlord, is restricted from reletting for 12 months, and you can't use any other sort of excuse like, well, it didn't sell and I need to rent it out because I can't afford to pay the mortgage. The rules are really solid. Why this exists? It's designed to stop misuse of the ground. For example, evicting a tenant under the guise of selling because you can command a much higher rent is really the reason of doing this. And we saw this a lot, particularly in our capital, of where families were evicted under the reason, or the reason would have been given is because they want to sell, and then suddenly reletting at a much higher rent. The practical implications: if the property fails to sell or the landlord changes their mind, they still cannot relet for 12 months from the point possession was obtained. All routes now go through the court, so timescales will be longer and more structured. The only exception is student accommodation and that definition of a house of multiple occupation. This is under a ground 4A, and this point many people have missed. Purpose-built student letting cycles are specifically recognised within the reforms. A student house of multiple occupation is 3 or more students It's let on a fixed term aligned to the academic year. And what's changed? Section 21 is removed, but landlords can use a specific ground 8 for student accommodation, commonly referred to as ground 4A. How landlords regain possession? To recover the property at the end of the academic year, the landlord must serve advance written notice confirming possession will be required. They have to have provided at least 4 months' notice, ensure the tenancy is clearly structured as student accommodation linked to the academic year. This allows the landlord to regain possession in line with the academic calendar, which is a key distinction from a standard family's APT. Why this matters? Without this provision, students could remain indefinitely on rolling tenancies, and landlords would lose the ability to reset for the next academic year intake. And this is an area where the reforms deliberately preserve landlords' control. So a typical post-reform timeline is a notice period is between 2 months to 4 months. Court process was 8 weeks to 16 weeks, and bailiff enforcement is 4 weeks to 8 weeks. So what we're saying now is the timeline for eviction from the previous Section 21 has now doubled. So the total time to take possession of a property realistically is 12 months, as far as I'm concerned, in my experience. But what I would, at this particular point, give you just a bit of personal observation. Landlords are really worried that the changes to Section 21 and the no fault eviction, and that concern that now you've got 4 months before the eviction process can take, and it can be 12 months before possession, could potentially be up to 2 years if the tenant challenges. And you've obviously then, even though the courts have granted eviction, in 9 times out of 10, you've got to get the bailiffs involved, which then adds further months and expenses. For the last 3 years, I've been personally taking out a landlord's income and legal cover protection. So what this means is, if I was to give an example, and these are just personal anecdotal examples, I receive £1,100 a month rent on property A. To take out landlord's income and legal protection, it was about £34 a month. What that means, the moment the tenant stops paying, after 1 month, the insurance policy kicks in. After month 4, the legal cover would kick in, and they would then take the eviction process through the courts and through the bailiffs. But all that time, I will be receiving rent. So if your landlord is really concerned, and it's a real concern that they could lose up to 2 years' rent, and to try and reclaim that back through the courts is really hard, by taking out a simple insurance product. So if you're using a letting agent, which is what I do myself, this would be advised at the point that a tenancy has been issued. You can get it retrospective, and the different policies run for different lengths of time. There's lots of different ones. The ones that my letting agents use are like Arc Legal, Gallagher, Rent Guard, Direct Line Landlord, Letting Hub, Hamilton Fraser. There's loads. There's You Insure, Select and Protect. I'm just trying to think of all the different ones, but definitely worth investigating. Periodic tenancies. The AST has now gone. However, their terms and conditions still apply. So the vast majority will be on periodic tenancies from the outset. So from the 1st of May, everyone's now on a periodic tenancy, unless obviously they were on common law tenancies. Replacing the old fixed term assured tenancy is literally the terms and conditions were extended through. You must remember that when a landlord says, well, a tenant has to give 2 months notice, but they've only given 1, it is literally 1 month's notice if they were on an AST. This means there was no set end date, and the tenancy will automatically roll over on a monthly basis, giving tenants greater flexibility at the end of the agreement. So what normally letting agents specifically would do is to try and get tenants previously on a 12-month contract and they would charge the tenant to renew that contract. Tenants did quite like it because they felt then they had at least a 12-month period of where they had some form of confidence. Tenants can leave now with 1 month more notice if they're on an AST and 2 months notice if they're on an APT. However, landlords must use a possession grounds 4 months notice with a minimum 12 months prior to issuing a notice period, so a minimum period of 16 months before eviction can start. Let me just re-explain that. If you moved into one of my properties on the 1st of August, you would get 12 months guaranteed in that property before I can evict you or give notice of eviction. That notice of eviction gives you 4 months before you have to move out. So you get the 12 months as a guarantee in the property, and you will always get that 4 months notice period. So somebody moving into one of my properties on the 1st of August would guarantee to have 6 months before they have to leave the property, 16 months. Once they've been in for 12 months, then it's a 4-month period before they need to move. And this has been the biggest structural change since 1988. Next is the extension of AWAB's law. AWAB's law initially for social housing, because it was in social housing where this happened, and it was a tragic case. It's now been extended to the private rental sector, allowing tenants to challenge unsafe living conditions such as damp and mould. And it was a real awful tragedy of where black damp mould accrued in a house. But a lot of this can be done by the modernisation and the improvement of EPCs can just by its nature sort of block up air vents that actually created the problem. Next is the key reform on rental bidding wars. Landlords and letting agents must set a fixed asking rent, and tenants cannot be asked to bid above the amount. This aims to prevent tenants from being forced to engage in competitive bidding of properties. So landlord and agents must advertise the property at a fixed rent and must not invite or accept higher offers. So I'm putting one of my properties up and it's going up for £1,500 a month. I can take £1,500 a month. I can accept less, but what I can't do is encourage tenants to outbid each other. Unfortunately, the last few properties that I've rented out, it was the tenants that were coming back to the letting agent because properties were very scarce in some of the areas where I have buy-to-lets, and they were outbidding each other. And now we have to absolutely not allow that to happen. So even if it's the tenant saying, Roger, I'll give you 100 quid more if I can have that buy-to-let, the answer's no. You must pick the right tenant who's passed the right references, but you can't accept a higher amount of rent. The legal requirement at this point on marketing, the property must be listed with clear asking rent. That becomes the maximum rent that we can accept. Accepting more than the advertised rent is a breach. Letting agents, and if you're actually marketing your property yourself, you might use open rent and you might market the property through one of the property portals. Enforcement sits with either you or the agent, and agents are regulated under consumer protection rules. And you need to make sure that everything is listed and there's audit trails and email trails and offer record trails. Tenant complaints drive enforcement. Tenants can challenge if they feel pressured to bid higher. Evidence is usually straightforward. Messages, emails, or screenshots. You cannot encourage or to increase the rents once it's been listed. Local authorities will be hot on this. Local councils can investigate breaches, issue fines and penalties, and take action against repeated offenders. And this sits alongside a wider enforcement of standards under the reforms. What landlords need to change is a set of realistic rates up front. So you really do need to make sure that what you list the property is realistic and it reflects the market conditions and it remains competitive. So make sure whatever you list it for becomes the right price and it stops any bidding. The practical reality, this doesn't remove demand pressure. Strong demand, properties are still likely to let quickly. It becomes a first suitable tenant at the asking rent, not the highest bidder. And I absolutely agree with that, is the fact that just because someone wants to offer a higher rent, if they haven't got the income to substantiate that, you're going to go into an arrears possession straight away. So this way comes to limit on rent increases. Rents can only be raised once a year and must reflect the market rate. Mid-tenancy rent hikes are no longer allowed. And I've just started reviewing my tenants' increase in rent, and I'll show you the forms soon. Rents can only be increased once every 12 months. It applies to all APTs and no more multiple increases within a year. And I think that's the key bit, because sometimes it wasn't unusual to increase rents every 6 months in certain parts of the country with certain landlords. That must stop. How must the rent increase be done? All increases must be served via formal Section 13 notice. That used to be Form 4, it's now Form 4A. And this is under the Housing Act 1988. So this increase in rent is how I would have increased my rents since 1988. I've always, for a long time, used the letting agent, and it's the form which is now Form 4A under that Section 13. That form's never changed, so it's still the same form. I must give 2 months' notice, and new rents take effect after that notice period. So I've got to wait. I can only do this once a year, and then the rent cannot go up for a further 2 months. So in reality, if you were to take a tenant in on the 1st of August, you couldn't put the rent, you couldn't advise on the increase of rent till the 1st of August next year, and then that rent wouldn't go up until the 1st of October. Now, can a tenant challenge the increase? The answer is yes, by the first tier tribunal. Tenant can refer the increase before it takes effect. The tribunal assessment, market rent, comparable evidence, and property condition. So the tenant can't just go no. The tenant will have to supply information of why the increase is disproportionate and not acceptable. They can't just go, you're not putting up my rent, because the tribunal will rule against it, and they can only challenge it the once. They could challenge it, the property was in poor condition, or the fact that, say, you'd put it up by 10%. What I have noticed is with my properties, the letting agents have used, they were charging me about £250 plus VAT to issue a Section 4A notice to increase the rent annually by £250. So if you are using a letting agent, you might find the cost that letting agent will charge to increase the rent that year will be equal to the increase in rent. However, if you let your rent not be increased regular, and you suddenly think, well, we haven't put it up for 4 years, so we're going to put it up by 6%, which actually over a 4-year period isn't that bad, it wouldn't go through. So again, you really do have to be careful and think through about those rent increases. The rent increase is paused until the decision by the first tier tribunal. The tenant continues paying their current rent. The tribunal determines the market rent, and the decision is binding. So the tenant could wait roughly till the end of the 2 months, challenge it, and it could take a further 2 months before the new rent is increased. There is a lot of market speculation that something like 30% of all tenants will challenge. In my reality, I do not think that will actually happen. I think there was some will challenge it, but overall, once they realise the way that the tier tribunal will work, then it will be a different outcome. There is no cost to the landlord to defend a Section 13 challenge. The tenant is charged. Landlords do not pay to attend or respond, and it's approximately £47 for a tenant to challenge the rent increase, but there is a cost, and in that itself, I think is positive that the tenant has to pay, but not the landlord. Can the tenant just keep refusing the increases? No. Only one increase per every 12 months. Each challenge is judged on market evidence. So they can challenge it every year, but once the decision's made, the rent increase then stands. What's an acceptable rent increase? There's no fixed cap, e.g. inflation, but it must reflect open market rent, local comparables, and property condition. Landlord's risk and the consideration is process is slower and more formal. Weak evidence may lead to reduced increases or no increases at all. So either the letting agent, the landlord, must provide to the tier tribunal exactly the justification of the increase in rent. Landlord's protection, the right to increase rent annually, and the tribunal provides independent validation, and tenants cannot block increases indefinitely. And then this kind of crosses over with the decent home standards. For the first time, private landlords must ensure a property meets the decent home standards, and this includes property maintenance and safety penalties. Now, I know where a local authority has a licensing program, we've got one in Birmingham, and if the tenant complains to the licensing officer that the property is unsafe, they will come out and they will inspect, and they will take action against you. They will write to your mortgage lender and let them know there's a breach. So it triggers lots of actions. So the decent home standard has teeth already, and it's about making sure the property is safe and the property has that decent home standards. So this is, there's no actual live date for the enforcement. The legal framework is being introduced under the Renters' Rights Act. The detailed standards and enforcement timelines are set through secondary registration, and implementation is expected to be phased in over the next several years. However, if you have landlords in selective or additional licensing areas, trust me, these rules are already in place when it comes to the local authority wants to and will jump on to any raised complaints about safety or the standard of property raised by the tenant. So what will landlords expect to meet? Safe structure and stability, adequate heating and insulation, good repair and maintenance, and freedom from serious hazards. But when it says about heating, there's also going to be a challenge against cooling. So if you've got a flat at the top floor of a large block in London and the windows are restricted to opening, there could be challenges around the requirements of providing air conditioning, or at least taking the cooling of the property seriously. So again, expect all sorts of challenges as the world starts to heat up, as well as consideration around heating in the winter. So how will this be enforced? Local authorities will have stronger enforcement powers. They already have in licensing areas. Issue fines and take action. What should landlords be doing now? Don't wait for the deadline. Start preparing the portfolio. Review the property condition. Identify older stock, EPC challenges, and potential hazards. So when we talk about the new possession grounds, landlords can repossess properties if they need to sell or move in themselves, but only after 12 months notice of the tenancy, with 4 months required. So a new tenant, new family moving in, guaranteed they've got 12 months before the eviction notice can be issued, and then they've got 4 month notice. And that in itself becomes the important grounds. Is the ground first is selling the property, then there's a ground for landlords or family moving in. The ground for rent arrears, normally 3 months, but the legal documentation cannot be issued till the 4th month. Ground breach of contract, a ground for redevelopment, and some grounds require a minimum tenancy period. So the tenant must have lived there 12 months before the 4 months notice period can be issued, with the exception of student accommodation that are on a fixed academic year, as long as there's 3 or more students in the property. This doesn't cover 1 or 2 bed student accommodation where there is only 1 or 2 students in there. No blanket ban on benefits or recipients or families. Landlords can no longer refuse to rent to tenants based on whether they receive benefits or have children, ensure a fairer access to housing. However, what that ultimately means, though, is now with the affordability cap that you've got, which people who are on benefits receive, unfortunately doesn't cover the average rent in the UK, which is about £1,200. So unfortunately,